Good morning. Meeting of the Michigan State Board of Canvassers. It's called to order. Public comment is, do we have anyone for public comment? Mr. Gallant is here. Is he online with us?
I believe so, yes.
Mr. Gallant, are you with us?
Yes, can you hear me now? It's James Gallant.
We can hear you, and it's wonderful to hear your voice, and you have 2 minutes, sir.
Oh, 2 minutes. Well, thank you very much, man. I don't know where that well, I'm James Gallant, Marquette County Suicide Prevention Coalition, and I'm now back to we could pick up our conversation, Mr. Chair, that we had that was blocked by the most recent past chair. She knows who she is. It's one of the worst examples of parliamentary procedure violations I've ever seen that was going on in the last couple of years here at the state canvassing board. You're now and congratulations becoming the chair. Now you're the Republican, and hey, supposed to be a party of laws and rules and guidelines. We're a nation of laws, right? So please take the steps necessary to refer the issue of, does the state board of canvassers required to follow Robert's Rules of Order as determined by Mike Brady, the director of legal services of Michigan Department of State, when he gave those instructions to the Secretary of State during the Michigan Independent Citizens Redistricting Commission at their first meeting, when the first meeting created under the Constitution. He came through before and said, this is the fundamental principles. Well, he didn't say that, but he inferred that they're the fundamental principles of parliamentary law under the Constitution because they're before the commission started. They didn't make any rules. They didn't make any rules for 4 months. So I'm asking you to please have that, because you have the information, the transcripts that I submitted to the public hearing when you changed the rules. You changed the rules. The application, this board, the State Board of Canvassers, submitted to the Joint Administrative Rules Committee of the House of the state of Michigan. You said you weren't going to change the rules, but then you changed the public comment rule. It's supposed to have 2 public comments, one at the end, one at the beginning, and you know this. They're already in there. So just get a real lawyer. Now, it's good that we have Adam Fracassi here, that he's an actual lawyer. This is good. There's ethical standards that I think is unbecoming of members of the bar to come to these and participate in these public meetings and not follow the rules. They're practicing lawyers under the authorization of the Michigan Supreme Court. They shouldn't be doing this. And this is what's going to go to the Attorney Grievance Commission. I see that, I don't know, in a minute, it was sketchy because you had public comment and then you went into closed session. How did you go into closed session? That's like pending litigation stuff. Okay, you went into closed session, come back, a motion to reconsider, a motion to rescind. Okay, wait a minute. You don't have that rule in your rules.
Mr. Gallant, your 2 minutes is, Mr. Gallant, your 2 minutes is up, sir. We appreciate your comments as always. Hope all is well up in Marquette, and thank you for calling in. Item number 2, is there any other public comment?
No.
Nothing. Item number 2 is a consideration of the meeting minutes for the September 19th, 2025 meeting.
To approve.
Second. Then moved and seconded. All in favor?
Aye.
Item 3 is a certification of candidates for the special election for the office of State Senate, 35th District. Director Brader.
Yes, thanks, Chair Housecamp. So this, the governor called this election to fill the 35th district vacancy in the Senate. So the special primary election is slated to be held on February 3rd of 2026, and then the general election will be held in the May election date in 2026. So you have the list before you of the candidates who filed. They all filed via payment of the filing fee as opposed to submitting signatures. So there were no signature petitions to review. There were no challenges to their affidavits of identity. That's something that's handled by the Secretary of State's office if there are challenges, but just for your information, nobody challenged any of their affidavits of identity. So the list of candidates you have before you are those who filed to run in the primary in both the Democratic and Republican parties.
Thank you, Director Brader. Questions? Comments? I would very much entertain a motion.
I move that the board certify the candidates appearing on the attached list as sufficient and be certified to the Secretary of State for the February 3rd, 2026 special primary election for the office of State Senate 35th District.
Support.
Been moved and supported. All in favor?
Aye.
Motion passes. Moving right along. Is there any other business to come before the board today?
I'll just mention, the board may have seen the sale of Dominion Voting Systems in the news to Liberty Vote. So we are, we don't expect that to have any major operational impacts on election officials' work or the board's work. There are some things that we'll need to update, obviously, like in our contract language with the voting system vendor. There are provisions in place where if the company is sold, then the successor company inherits those obligations. But we will need to update all of our contract language and everything to reflect the new company. But the new company is called Liberty Vote. It was sold and is a freestanding separate company called Liberty Vote. The owner is Scott Leindecker, who is also the CEO, I believe, of No Inc., which is another election system company. They don't make voting equipment, but they make electronic poll books and voter registration management systems. But these will be separate companies, is my understanding. So we're going to be meeting with the new leaders. Again, we don't expect really major staff changes, but we're going to be meeting with the new leadership or the leadership of the newly formed company soon, and we'll keep you posted as to any impacts there. But essentially, we're not really expecting any major changes. And of course, we already have the new voting system purchase coming up for next year anyway. So we would be dealing with the board considering whichever vendors would be seeking to serve our state in the next 10 years, regardless.
Thank you. Any comments or questions for Director Brader?
Yeah, just for clarification, when do the new systems have to be approved by the state?
I'm not sure is there a specific deadline in statute for the approval, Adam?
The contract.
Yeah. So, I mean, in order to have a new contract in place, we would, we're going through the process of, first having, putting together the requirements, which we're doing with an advisory group that consists of local election officials. And once, that process is ongoing, and then we would then, put that information out as we would generally for requests for proposals. Vendors have a chance to ask questions, and there's opportunities to change that. And then the board, of course, has to approve the voting systems as well. And that all ideally should be done, or really needs to be done, so that we can have new contracts in place when the current contracts expire, which I believe is at the end of 26, or is it sometime in early 2027? It's the end of, thank you, the end of February 2027.
Thank you. There's one other item I would like to bring up this morning, and that Vice Chair Gurwitz has asked about the petition circulating procedures that we had previously discussed and moved forward on. We didn't move forward on, we delayed action on. We are not going into a full discussion of that this morning, but I think we would like to bring that back onto the November agenda. And Mr. Frakazi, you have some information that you'd like to share that we were going to kind of use as a checklist coming into November.
Yeah, I have copies of the procedure where we left it at last. So I'm going to send the board home with some homework. What I need from the board, essentially what the point of this procedure is meant to govern is when we receive this type of challenge in the future, what it needs to govern is what is the direction that the board wants us to do? What are those steps? So that's kind of the framework. What the key pieces that really I need to know are Not as much of like processing it from the terms of validity. I think that's established. That's the signature review process. It's handled on a case-by-case basis. Like every other signature for a voter, we would handle it that exact same way. What I need to know mainly from the board is when a challenge gets submitted, what steps does the board want us to take? Should we go in and immediately request documents? What documents are ideal that you would like us to be requesting? At what point do we bring it back to you? Do you want us to send something and notify you? So it's some of that procedural stuff is really what I'm trying to capture with this. So how it seems to make sense to me is, and this is based on kind of what I heard at the last meeting, is that the starting point for this really is going to be, does this impact ballot access in the sense of we're going to process the challenge regardless, but the timing, it's a question of timing. If the challenge does not bring enough into play to affect the status of the ballot of the candidate's access to the ballot, we're going to do that at the end. Because even if you accept all of the challenges, you presume it's true, if they're still going to be on or off the ballot, regardless of where we land, we'll do that, but I'm not going to prioritize that over other candidates. So or other challenges, excuse me. That's the starting point. But again, that's just a question of timing. So even in that instance, I still need to know what should we be requesting and when. From there, what we did with the West petition is probably the same. Like we would look it up in qualified voter file. We would look the circulator up in the qualified voter file and see, is that person registered to vote? If they're registered to vote in QVF, we can compare the signature and make a determination. And then if they're not in QVF, then we contact and say, provide a signature exemplar. We need something from you for that we can compare and make a determination. So that's, I think, at a very high level, like the basic steps. And then from there, we'll make the determination. We'll review the documents. We'll draft a staff report. We'll present it to the board. I need to know though, from mostly, does that make sense? Does that like procedure make sense to you guys? Is that what you want us to do? Are there different steps you want us to be taking? I think that's really the key as to what I need from the circulator challenge. I'm thinking of this in the sense of very similarly like to recounts, where when we have an election, we always ask you to just let us start a recount immediately with that motion. And the reason we do that is because we have a very tight window. And if I have to come back after every challenge and ask for the board's permission to do something, I have 50 days to process hundreds of thousands, if not millions of signatures that come in a candidate filing window. And we have 50 days to process all of those and do a staff report. I would be extremely concerned about timing if we have to schedule a board meeting every single step of the way in that 50 days to take steps. So as much as I can just get that, this is the basic framework that you want us to follow. If this doesn't work, then we come back to you. That's fine. That's what I'm really trying to capture with this. So that's pretty much those are the big pieces that I need out of any sort of procedure that we do. So I have copies printed. I'm gonna send these home with you and ask that you take a look at it again in advance of the November election. If there are things that we need to explain more, things that we need to change, things that we need to address more. And if what I have just said is not explained clear enough, let's make sure it is in this as well. So that's what I'm going to ask that the board provide, so we can get something established for the November meeting.
Perfect. Questions?
Yeah, I think when we discussed this before, it's kind of an interactive thing, but we need to know from you. You want to know what we want, but we need to know what the timing is, because we suggested at one point, I believe, or at least discussed the possibility of having the ballot question committee or the candidate, right? Because this is also.
This would only be for candidates. This type of challenge is not allowed for a ballot question.
Oh, okay. So that,
Yeah.
okay. So, so we need to, we suggested having the candidate provide validation of signatures at the time that they submit their signatures, right? And you thought that that was unworkable?
I think you need a statute change for that. That's the problem.
To require
Yeah, to require it.
But, okay, let's say you don't require it, but you suggest it. I think it's difficult when, it's more difficult with volunteer circulators who most likely are going to be registered voters in Michigan. But if you have paid circulators, so you might not ask them to submit signature exemplars for everybody, but could you suggest that they do it with regard to paid circulators who are neither registered to vote nor Michigan residents? Because those are the two categories, right? Those are the ones whose signatures you cannot validate. So could you say, if you have out-of-state circulators or unregistered circulators, provide at the time that you submit your petition signatures, provide handwriting exemplars? Would you do that? Is that workable from your perspective?
I think if you made it a best practice and kind of say that, yes, and say like, we would encourage you to do the following, and then follow that up with, if they don't, and we receive a challenge, then what? Then would we reach out? Like, then I would presume we would reach out and say, we need X, Y, and Z from you.
Right. So if they don't submit it at the time that they submit their signatures, then the timing with regard to responding to a challenge is pretty short, right?
It's in statute as 7 days. It is short, yes. It's direct in statute. I can't remember the
Right.
exact
I
time,
mean,
but yes, it's
that's
short.
what we have to deal with, right? That if there's a challenge, and I think what we said before was if the challenge appears to have merit. So if we have the kind of challenge that we had with Cornell West, there were some signatures that there were examples of different signature style or whatever. There was some indication of forgery. If the challenge is immediately not on its face, one that we have to deal with, then so be it. But if it does appear to have merit, then we need to, that's the procedure that we need, right?
That's
That
correct.
if they have not submitted the exemplars at the time that they submitted their petition signatures, how much time do they have to respond to a challenge? And if they don't respond, what is the consequence?
So I think the thing that's really what I need. So to me, the steps basically that again, this is up to you, but this is what I'm thinking I've heard. So, is that we would receive a challenge. We do kind of that like initial review, to determine, I'm going to say facial validity very loosely, like, but that is this like, I can't remember the words that you just used. But that kind of initial review. And then from there, we would be immediately reaching out. If we don't have anything, if we have no exemplars, I want to be able to draft a letter and immediately reach out to them and say, I need this information and I need it within X number of days. And presumably they respond, they get us the information, we process, and we then kind of go through the rest of the steps that exist. And then if they don't respond, I think we would have to come to the board at that point. I don't know what other, and maybe I'm wrong on that. Maybe we can think of that piece of it, but I don't know what next step after that.
If we're talking about best practice, it seems to me that one of the things that we could say is you should be ready to submit handwriting exemplars for your petition circulators if they are challenged. You should be ready to do it really.
I think if we had that as a notice on the web or as a suggestion somewhere that says, if you're using paid circulators, or if you're using circulators in general, and they are, for example, out of state, be ready to provide that information. But if you don't provide that information, here's how the board is going to view it, right?
Right.
So you kind of have a third tier here, right? You
Yeah.
have a signature that's okay, you have a signature that's obviously fraudulent, and now there's this third tier of no sample provided, and we're going to make a call based on that.
Which is kind of what we ended up doing with West, right? We had some where we had an exemplar and it matched. We had some we had an exemplar and it didn't. And then a couple where it's like we had nothing.
So if we had that as if we could put that out as a best practice without legislative anything, and we could also, I mean, forewarned is forearmed, right?
Yeah, and we do that in general with candidates with the petition manual itself. Like we have best practices in there throughout for that exact reason. Like we can't mandate you. However, it's strongly encouraged to do X, Y, and Z because if you don't, then it may affect your status, right? Like if you scrub your petitions, right? We always encourage candidates to look through their petitions and look for those things and mark them so it doesn't get pulled in a sample, for example, like cross it off. That's just an example of a best practice. Pull a registration list, you know, like we can't mandate you do that, but we use that as a best practice. So I think we can do things like that with this too, to say, you know, it's a best practice to get an exemplar here. You know, an exemplar could be a driver's license or an affidavit or some other like form that that shows. I was gonna say W something, whatever, yeah, whatever a tax document, right, that has that. So yeah, I think we can do best practices. I think the timing would be it's less than a week. Just because again, it's a very tight
And
turnaround.
you could extend your best practice to offer them two approaches, either be ready to send the information in, or otherwise, when you send your forms in, if you have out-of-state circulators, make those signatures available. Make those samples available along with your submission. Is that also acceptable?
You know, it seems to me that this is going to be with regard to state candidates. The West petition was difficult because it was an out-of-state candidate and out-of-state circulators. And so and when the campaign was over, getting compliance was quite difficult. But we don't anticipate that challenge, that difficulty with regard to state candidates for state offices, right? We hope.
Well, yeah, I mean, certainly the candidates, I hope will be in Michigan. But I mean, there could be, so in 2022, one of the issues was out-of-state circulators. I mean, like, we were in a different situation back then because we were talking about the petition signer signature validity. But, you know, if there is what is similar about now to 2022 is you've got a lot of candidates, a lot of statewide candidates. So you might be having similar competition for resources for getting petition circulators. Hopefully, the candidates and the campaigns have seen what has happened and are prepared to submit valid signatures. But you could see a substantial number of out-of-state companies or circulators being utilized just because of the competition for resources. So I think we could still see a fair number of out-of-state circulators this year or next year.
If we provide them with those guidelines, and we make those guidelines crystal clear, we make them extremely accessible. And challenges are made on those signatures and there is no sample on file and they fail to follow up with your request within X number of days. I mean, to me, that makes it really crystal for us as a board to simply say, yeah, we're going to invalidate these circulators, the work of these circulators. And these folks all knew what the rules were coming in. If that's within our province, that would be an interesting discussion.
Yeah.
That makes sense. So yeah, I mean, I think, you know, at a more detailed micro level, we're certainly looking for the processes that you want the Bureau to use in terms of getting information in when, like to Adam's point, because we can't go back to you for each decision. We want those laid out as much as possible so that we're processing this the way that you would like us to. But then also sort of at a macro level, when we get to that deadline, which is very tight, we want to be in a position where we have minimized the number of petition sheets where there is a dispute about whether it was signed, essentially, whether the circulator signature is actually the circulator's signature. If we can minimize the number of those that are in question, it will minimize the chance that whatever sheets are in dispute actually affects whether the petition is sufficient. Because if it's not in dispute, then the board can decide on the petition, and then we'll have more time if we need afterwards to see if we need to investigate or refer anything through the criminal process. But the board's work in terms of determining who has sufficient signatures is done. If we have more, there's sort of the more circular signatures that are potentially in question because we can't tell you for sure whether those signatures match the circulator signature, that will just increase the chance that the board gets put in that position where you have one side telling you that this circular signature is not actually the circulator, you have the other side saying that it is, and the Bureau can't tell you definitively either way who's right. And that's going to be the hardest decision for the board to make. So we may not be able to totally eliminate that possibility, but minimizing it would be very helpful for everybody, I think.
We could at least provide a safety mechanism for us where we can say to someone using paid circulators, we don't have a way to compare your signature. We gave you the ability to send those samples in ahead of time. We asked you for the samples afterward. I think it gives us an easier way to handle disputes. And it does it without. Are there any, we're not creating a legal challenge there because you're not requiring it. You're simply putting it out as a best practice, right?
I don't believe so. That might be a
Yeah.
question for the Attorney General's office, but I mean, again, it's not something we're requiring them to do.
But it really, when you talk about best practice, you're giving the candidate information about the best way for them to, that's what best practice, but the best way for them to actually accomplish their goal of getting on the ballot, right? So what you're saying to them is, if you want to get on the ballot, maybe these are things you should do.
Yeah, here are the best ways to basically have a smooth process. The only, just to be clear, I think the best practice is fine. I don't think we can just immediately disqualify for failure to response. We still would have to review. We still would be presenting you with a recommendation or maybe a non-recommendation based on what's in front of us, but we would say, this is what we have. We don't have anything to respond to.
No, we would want
But
that.
it looks valid. They haven't responded to it. What do you want to do?
Yes. So I just wanted to be crystal clear with that.
That decision has to be ours, is what you're.
Just the same as it is now. Yep.
Right.
When we do, and that would come with the staff reports at the certification deadline. We would write it up and say, here's all staff reports, maybe less than 50. That would be nice this year.
So that would be part of your staff report and simply say these signature gatherers did not have a sample and they did not reply.
Yeah, and here's what happened. Here's kind of like BOE's review. If it's easy for us to make, if we can make a determination, great. As you're aware, sometimes there are things we can't, and we say, here's kind of both sides board. Staff can't make a recommendation on this, so it's up to you. So I just wanted to be clear with that we are not
No, you're
rejecting
not.
solely.
We're not asking, we would not ask you to automatically reject those. We would ask you to provide the information to us so that we.
He's saying that they can't automatically.
No, I get that. I get that.
Yeah.
Yeah, it sounds like we're all on the same page.
Yeah,
So
right.
yeah, with that. Okay.
All right. Is there anything else? Questions, comments? I would entertain a motion to adjourn.
So moved.
All in favor? Meeting is adjourned.